Morning, everyone. I'm just waiting for a few more people to join before we start. Morning, everyone, and welcome to this talk on hints and tips on the Building Safety Act. I'm going to be leading on this talk. My name's Simon Murphy, and I'm a housing management partner with House Percival. My colleague Ewan Treadgold is going to be co-presenting with me. He's also a housing management lawyer with HP. So, for those of you who've had any interaction with the Building Safety Act in the past, you'll be aware of its esoteric, almost Kafkaesque nature. It is, in short, very difficult to understand and to get your head around. So I apologise. The next 20 minutes will not be easy to hold your interest, but we're going to try our best. The Act itself has a number of different definitions. It has a number of different procedures, processes, regulations, assessments, inspections, and certifications, which apply at various different times, along with a whole host of nuance and complexity regarding the safety of buildings in the UK. This webinar could easily be 20 hours, and sadly, even in 20 hours, we'd still not cover all of the elements of the Building Safety Act. But I hope you come away today with some practical points that will assist you. The key point for today is to outline some common issues that we're seeing in practice, along with some practical steps you can follow to ensure that you've complied with the legislation or are aware of when the legislation applies. The reality is that if the Building Safety Act comes up during your working day, it's likely that you will need legal advice. It's difficult for practitioners to understand and advise on, so we would not expect non-lawyers to be able to follow the legislation in this area with any great ease until they become more accustomed to it. We'll start today with a bit of background and context before moving on to discuss some of the more specific elements of the Act, namely the concept of the accountable person and the need for landlord and leaseholder certificates. We'll then talk about remediation and safety measures. So let's start with a bit of background. I'm sure you all remember the terrible incident that there was the Grenfell disaster, a fire that broke out in a high-rise building. This tragic and horrific event had at its heart issues surrounding fire safety and inadequate cladding. The Grenfell disaster pushed the government to introduce a number of different pieces of legislation, some relating to new fire safety procedures and others relating specifically to the construction and materials used in high-rise blocks. The Building Safety Act encompasses a number of these different elements. So if you find someone asking you a question about fire safety or about the type of cladding on the exterior of a building, or whether that balcony in the flat has the correct fire protection, you'll need to think Building Safety Act. Have we complied with our obligations? Whilst perhaps I'm critical of a number of the provisions in the Building Safety Act, I recognise that this type of legislation is essential to ensure building safety in the future and to avoid tragedy occurring again. The Building Safety Act is ongoing, and it's an evolving piece of legislation. New parts are to be enacted as time goes on. So do not think that once you know one thing, that it will stay like that forever. The law continues to evolve, and you need to continue to update your knowledge so that you keep abreast of those new developments. So when does it apply? And what are relevant buildings and what are high risk buildings? So a really important point is if the building that you're looking at does not fall into one of the following criteria, then the Building Safety Act does not apply and you need look no further into it. The Building Safety Act is focused on tall buildings, but do keep in mind that other fire safety legislation and other rules and regulations apply to those lower rise buildings. So the first thing to look at is the building itself and ask the following question. Is the building over 11 metres or 5 stories? If it is over 11 metres or 5 stories, then the Building Safety Act is likely to apply. But how do you count those stories? It's meant to be simple. You start from the ground floor. Um, so if you've got a car park in the basement, or if you've got a lower ground floor flat, they don't need to be considered when calculating the number of stories in the building. You're just looking at the building from street level and counting the stories above ground. If you have less than 5 stories, then the Building Safety Act doesn't apply. When you're looking at how many meters tall the building is, you're measuring from the ground floor level to the finished surface of the floor of the top story of the building, not to the rooftop. It's the finished floor level on the top of the story. Any plant or machinery on the roof can be ignored. It's the finished floor surface on the top story that says habitable that you need to consider. Again, as with the number of stories, you're measuring from the ground and the street, the ground or street level. You're not measuring to include the lower ground floor or basement. Okay, so we have our building and it's over 11 meters or 5 stories. This means that we're likely to be looking at what the law calls a relevant building. A relevant building is a building in excess of 11 meters or 5 stories and contains at least 2 residential dwellings. So, for example, you could have an office block in excess of 11 meters high, which is entirely offices except for a penthouse apartment. But that wouldn't be caught by the Act because it only has 1 residential dwelling. What's a high-risk building? A number of the points raised in this talk apply to higher risk buildings equally to relevant buildings, but higher risk buildings have additional requirements. The additional requirements involve registration of the building with the building safety regulator. You will also need a long-term strategy for involving residents in the building safety decisions. I haven't got time in 20 minutes to provide as much detail in this presentation on higher risk buildings, because frankly, a high risk building could be a whole presentation in itself. But what is a high risk building? It's a building over 18 meters or 7 stories high. So as with relevant buildings, we're counting from the ground upwards. If you've got a building which is over 18 meters from the ground, you should consider specialist advice because of the registration requirements and the paperwork needed. But one thing that I wanted to highlight is you've got a fast approaching date which you need to comply with of the 30th of September 2023. You need to make sure that by this date, if you've got a high risk building, that it's registered with the building safety regulator by that date. Registration can be done through the Health and Safety Executive website. I'll hand you over to Ewan now to talk about the accountable person.
Thank you, Simon. So the accountable person, this is an important concept in the Building Safety Act, as it is the accountable person who will be responsible for ensuring compliance with the relevant rules under the legislation and for the maintenance of the building. An important point to note is that this does not have to be the freeholder. That accountable person is the person responsible for building maintenance, but it could be a management company. It's not always the person who owns or the entity that owns those bricks and mortar, but the entity that is responsible for the building's maintenance. So it would be important to check any terms of any leases or title deeds to ascertain exactly who is responsible for that maintenance of the building, as it's them who will be that accountable person. In the sort of context of social housing, you may find quite often you're the freeholder, and it's likely that as a social housing provider, you'll be the accountable person and responsible for that building's maintenance. Uh, However, I have seen on large developments where there's perhaps a social housing element on the estate, that social housing element is leased to the provider, um, and therefore it may not be you, sort of social housing providers, who are responsible for the building maintenance across the estate. It'll be important to check the terms of any leases, any title documents, just to ascertain who's maintaining that building, who's responsible for it, because they will be the accountable person. Uh, as I say, the accountable person is responsible for building safety risks when a building is occupied. There can be several accountable persons across an estate for a building, but only one of them would be the principal accountable person. Back to you, Simon.
Thanks. So I want to talk to you now about leaseholder certificates and qualifying leases. The Building Safety Act often refers to the concept of a qualifying lease. If a lease is to be held to be a qualifying lease, then it provides the leaseholder with certain protections under the legislation. So a lease will be considered to be a qualifying lease if the following apply. One, it's a long lease granted for 21 years or more of a single dwelling. The tenant under the lease is liable to pay a service charge. The lease was granted before the 14th of February 2022. At the beginning of the 14th of February 22, the following applied, and the dwelling was the tenant's only or principal home. The tenant did not own any other dwelling in the UK, or the tenant owned no more than 2 dwellings in the UK apart from their interest under the lease. If these criteria are met, then the lease is deemed to be a qualifying lease. If you are the landlord, you can obtain a leaseholder certificate from each flat owner and determine which leases in a building are qualifying leases. This will tell you which flats benefit from protection under the Building Safety Act, and are required to make contributions to repair or remediation under the Building Safety Act. If the landlord wants to obtain a leaseholder certificate, you just need to ask the leaseholders to complete the certificate. The certificate's available on the government website. The request from the landlord to the leaseholder needs to include the following. Firstly, the letter must be left at the address of the tenant or sent to the address as a prepaid first-class letter. It can be sent by email, but even if you're sending it by email, we would advise that you do it by post, so that you've got a record of it. And special delivery, the track and trace option works really well. So it is quite expensive, but on the other hand, you have proof then something has been delivered. The letter must state that it is a notice for the purposes of paragraphs 13 and 15 of Schedule 8. The letter must include a blank copy of the form of the leaseholder deed of certificate. The letter must state that the reply date, and this must be no less than 8 weeks from the date that the notice is received. The letter must state the address of the current landlord and where to send the reply. The letter must include a statement which explains that failure to complete the certificate will have any of the following consequences. 1, the lease will be treated as though it is not a qualifying lease, and/or 2, the landlord may assume that you own 100% share, even if your lease is shared ownership and you haven't staircased to 100%, or 3, the qualifying lease may be deemed to have a higher value. I've put on the screen a link to the government website where you can find the form of leaseholder certificate. Ewan.
Thank you. So landlord's certificates now. So these are important, and specific timelines apply uh, for the responses that need to be provided to leaseholders. So if you receive a completed leaseholder certificate, then as a landlord, you're then required to supply the landlord's certificate. This must be done within 4 weeks of receiving that completed leaseholder certificate. The specific times when you have to provide a landlord certificate are as follows. So if you're making a demand for remediation work, then you would need to provide one. As I mentioned before, within 4 weeks of receipt of a leaseholder certificate, or receipt of notification from the leaseholder that the leasehold interest they owned has now been sold. If you've become aware of a defect that's not covered by a previous landlord certificate, then you've got 4 weeks again to provide the new updated landlord certificate. Another occasion might be if you become aware of a new leaseholder certificate that contains information that wasn't included in your previous landlord certificate, then yeah, you've got 4 weeks again to provide that updated landlord certificate. You'll find that these landlord certificates are really quite detailed, and they require quite a lot of information. That the leaseholder ones are much more straightforward. But thankfully, you as social housing providers, you're exempt from certain elements, and the form itself does make clear where you are exempt. But one example being there are questions talking about group net worth and yeah, sort of lots of accounting information, which you find that social housing providers are exempt from. And there's an option on the landlord certificate to just say you're exempt from providing that information. If you've acquired a building from a developer after the 14th of February 2022, then you should ask them to provide you with a landlord's certificate. Remember, we're only talking about those 11 meters, 5-story high buildings. That's when you need to do your leaseholder and landlord certificates. You don't need them for those buildings under that 11 meters, that 5 stories high. Yeah, you don't need to provide the landlord's certificate for those. If a leaseholder asks you for a landlord certificate and they have provided you with a completed leaseholder certificate, then you must provide them with the landlord certificate within 4 weeks of receipt of that completed leaseholder certificate. Really important. Really important that you meet the timelines. Yeah, and unless you've completed these landlord certificates before, so if you're getting requests for them and you haven't completed them before, then it might be a good idea to sort of seek legal advice just for help of completion of them in the first instance. Once you're used to the content, once you're used to the requirements, social housing providers will probably find it much easier to complete these without the need for legal advice. But when you first look at them, they're a bit daunting, and we think legal advice would be the best approach on that occasion. Back to you, Simon.
Thanks. So moving on to building safety measures and remediation, there are two separate concepts under the Building Safety Act. The key difference being that if something is a building safety measure, then the cost of it can be passed to leaseholders through the service charge. A building safety measure can include a risk to safety arising from the spread of fire, structural failure, or any other matter prescribed in regulations by the Secretary of State. As you can see, that's very broad. So a number of measures that are implemented can be passed on to leaseholders through the service charge. It's essential that you should consider carefully what you are charging the leaseholder for in the service charge and the extent of what you can charge. The charges related to building safety measures will be in addition to the usual service charges for maintenance of communal areas and cleaning.
On to a bit about remediation then. So remediation works are the works needed to remedy those historic defects in the construction of a building. It's the removal of that unsafe cladding. That's what the remediation works are about. In some cases, the costs of these works cannot be passed onto leaseholders at all. And in other cases, the amount that can be passed on is capped at a specific sum. So there are three main categories of building safety costs, and each with their own nuances and rules. We've got the costs relating to ongoing safety, which Simon just previously discussed. We've got number two, the cost of removing the unsafe cladding. And we've got number three, which is the cost of remedying relevant defects in relevant buildings where the defects are non-cladding defects. Okay, so as I say, Simon dealt with category one, and yeah, has discussed that already. They can be passed to leaseholders through service charge. With category two, this specifically relates to unsafe cladding, and the cladding would need to be tested to determine whether it is safe or unsafe. You may sometimes find that unsafe cladding has only been used in very small parts of the building and does not always need to be removed. Advice from a surveyor and fire safety expert would be crucial to determine the extent of and use of the cladding and how best it can be remedied. The key part of that category two is that you cannot pass the costs for removal of unsafe cladding to leaseholders through service charges. However, this only applies to residential tenants who have a qualifying lease. This qualifying lease is being discussed earlier in the talk. It appears that it will be possible to pass on some of the costs for that removal of unsafe cladding to commercial leaseholders. Category three, we're on to the non-cladding defects, which cause a building safety risk, and you will find that some of these costs will be subject to capped contributions in the service charge. Whether you are able to charge for certain contributions is often contextual and depends on responses provided in that leaseholder certificate. There is a permitted maximum service charge that can be charged per annum in certain circumstances, at the cap being £15,000 if the property is in London or £10,000 outside of London. When you're considering those category three sort of non-cladding defects, you need to be aware that there's an exemption for leaseholders holding lower value leases. I think this might be quite relevant for social housing providers because leases below the value of 325,000 in London and 175,000 for all other leases sort of outside of London means that they will not be required to make payments through the service charge for those remediation work under this category three non-cladding defect. As I say, likely to be applicable to shared ownership leases granted by social housing providers, unless that tenant has staircased their lease to 100% ownership. But just thinking about value, this is calculated by reference to Regulation 9 in the Leaseholder Protections part of the Building Safety Act, and value will be determined by the price paid if the lease was sold after the 31st of December 2020, and that can be found in the land registry title. And if it has not been sold since the 31st of December 2020, then you would look to Regulation 9, follow the calculation to work out the value of that lease. Back to you, Simon.
Thank you, Ewan. So one final point. For those of you who deal with the transactional side, I'm thinking specifically when shared ownership properties are bought and sold, you'll be familiar with various forms that need to be completed or questions coming in from solicitors. Be aware that the standard forms LPE1, for example, do not deal specifically with Building Safety Act issues as they need some updating. Be prepared to have lots of additional inquiries from buyers' lawyers relating specifically to the Building Safety Act where it applies. So you might want to consider collating some standard responses to questions relating to the Building Safety Act if they're arising regularly to save yourself time. So to conclude, well done for staying awake and keeping engaged in this presentation. Is not an easy subject and it's only going to evolve and become more complex over time. If you take nothing else away from today's presentation, just remember that if you're looking at tall buildings, then you need to consider the Act, and it goes without saying that you need to think carefully about maintenance and safety of those residents. Another point that I emphasised earlier is do not assume that because you did something, say, 6 months ago relating to building safety, that the same applies today. It's a constantly evolving and changing landscape, and it can change quickly. So seek legal and surveying advice unless you're up to date with the relevant law. So that's all of the formal part of the seminar. I just see that there's a couple of questions, and please do feel free to ask more questions in the Q&A box if you'd like to. But we'll start by answering the two questions that we've got at the moment. So I'm going to be mean and say I'm going to ask the question and Ewan's going to answer it if it's all right. The first question is, what are the implications if leases have been extended and the completion date of the extended lease falls after the 14th of February 2022?
Excellent, thank you for that. So I don't think the Building Safety Act has dealt with lease extensions particularly well, and it's not completely clear yet exactly what happens. But if you've got that lease extension, and this is our understanding, is that if the lease extension completes after the 14th of February 2022, because of the nature of the way a lease extension operates by surrender and re-grant of the lease, they, any protections that that leaseholder might have had under the Building Safety Act would disappear and would dissolve, because you've in effect got a brand new lease starting after the 14th of February 2022. I would expect to see leaseholders requesting additional clauses to ensure that protection continues once the lease is extended. I hope that answers the question there.
Thanks, Ewan. And one more right at you, and that is there any information that you should be providing to tenants about the Building Safety Act?
Yes, yeah. I mean, I often think that more information is better in these circumstances. I think specifically when you're looking at the high risk buildings, those over 18-meter buildings, there are specific requirements to provide what I think they call it prescribed information in the legislation, and there are specific things like that. There's a statement that the premises consist of or includes a dwelling in a high risk building, sort of when you've got to send this information out to your tenants, if you're the landlord, if you're that accountable person, the landlord, the owner. So yeah, you've got to include a statement that the premises consists of or includes a dwelling in a high risk building. You'll include name, email addresses, telephone numbers of the principal accountable person and any special measures manager, and information relating to the building safety regulator. Postal addresses in England and Wales for service of notices on principal accountable persons. Postal addresses for the building safety regulator, and rather helpfully, we've got a catch-all provision as well, which is any other information as prescribed in regulations made by the Secretary of State. So it appears, so that's the main information you provide, and it appears from legislation that service charge is not deemed to be due until all that information has been provided. That's specifically for higher risk buildings. But if you're those over 18 months, but I think if you're looking at over 11-meter buildings, I would be inclined to look at that point in detail and make sure you're providing it. You don't want to be in a case where you've issued service charge demands and aren't able to collect them due to the fact that you haven't provided prescribed information. Hope that helps.
Brilliant. Thank you very much, Ewan. There aren't any further questions, so thank you very much for giving up your time to listen to us this morning. We'll send you feedback forms, so please do give us feedback. If there are other topics that you would like us to cover about anything concerning social housing, then please let us know and we'll try and facilitate that. Thanks a lot. Happy Monday. Take care. Bye.
Thank you.